Hi everyone. So my name's Alex. I'm a senior associate in the employment team here at TV. This is my second stint of structuring success after running it last year. And in terms of what we're going to talk about today, we're really going to talk about what typically early stage startups look like from the very beginning. So you're obviously going to have your founders. So maybe one founder, maybe two founders, maybe more. But essentially you're going to have your founders, then you're going to have your different methods of engagement for anyone else that you bring on to support you and your business going forward. So that might be in the capacity of an NED to provide ad hoc advice and to potentially be a chairman for the board as time goes on. It might be employees to do the day-to-day duties, or it might be consultants to provide ad hoc advice or services on a much more sporadic basis. So they're really the sort of key types of engagement. But what I wanted to do is also run through those in a bit more detail of exactly what those types of categories mean, and where some of the sort of trip hazards are as well. So probably the easiest place to start is with employees. So employees are in essence, individuals that are engaged by a business to provide services. Personally, there is a responsibility on them to provide certain duties and time commitment to the business. And in return, there are certain minimum employment rights that they are granted. So in terms of those minimum employment rights, that includes the right to sick pay, the right to holiday pay, the right to certain types of family leave, the right to a written statement of terms and conditions at the beginning of employment, for example, and then also on termination, some degree of protection. Some of that is time dependent. So one of the key sort of issues there is if someone's got more than 2 years service, then they will gain what's known as ordinary unfair dismissal rights, which means that it's much more difficult for an employer to dismiss. There are certain hurdles and procedures that they need to go through to demonstrate that a dismissal is fair in those circumstances. But separately, employees also have other rights, including the right to be protected from whistleblowing. The basic example of whistleblowing is if you worked in a supermarket and you found your boss with their hand in the cash in the cash till, and you said to them, I'm going to report you to head office, and they said you're fired. That's whistleblowing in essence. And then also discrimination based on a number of protected characteristics is a potential consideration there. So that's employees very much in a nutshell and very much at a high level. But one of the key considerations for companies are that if you are bringing on employees, there are certain minimum obligations, including the need to pay those individuals national minimum wage. But in return, there are also benefits. So if you engage someone as an employee through an employment contract, the position at law is that any IP that they generate will automatically reside with the employer. Now, we would always encourage that you have more robust IP terms in there. That's something that Jeff's going to talk about a little bit later. I'm not going to ruin his part of the presentation or spoil that. But in terms of that is a key consideration why quite a lot of early stage companies actually take the view of, rather than someone be a consultant, we want them to be an employee because we've got a little bit more clarity on IP. So those are the types of considerations for employees. Then in the middle, there is a category known as worker. And now this has got quite a lot of coverage in the press recently, particularly with cases like Uber, where people who potentially might have been classed to be self-employed previously have actually been classed to be workers. And that's had a real impact on these disruptors, as they're known, who have put together business models which are essentially being caught up with by the tribunal system. In terms of workers, just to give you again a bit of a high-level overview, so it includes employees, but it will also include an individual who's entered into a contract personally to perform any work or services for another party, as long as that other party is not a client or customer of any business carried on by the individual. So it's a slightly niche area, but it's important to be aware of it because workers are entitled to, although more limited range of statutory employment rights than employees, they are entitled to a lot more than a genuine self-employed consultant. So that includes discrimination protection, right to accrue statutory minimum amount of holiday, and other considerations similar in that area. So it is worth being aware of that in terms of how an individual engage, what their time commitment is, how they are providing those services. And I'll come on to that in a little bit more detail now when we talk about genuine self-employed consultants. So genuine self-employed consultants are those that provide services to another party in the course of running a business or profession in their own right. They have very few statutory employment rights, but they are able to claim certain minimum rights, such as the right to a safe working environment when working at a client's premises, and are also not entitled to be discriminated on the grounds of a potential protected characteristic. But they are carrying out those tasks for a limited period of time. So typically consultants will have essentially a lot of outside interests. They will be providing services to a whole host of potentially similar sized companies. They might be doing half a day a week or even less than that in terms of their time commitment overall. And that's really what differentiates consultants from employees. Again, I touched on the IP point with employees, so I think it's important for me to touch on it in respect of consultants. So the position at law with employees that we just talked about is that IP automatically resides with the employer. That's not the case at all with consultants. Again, it reflects that reality of essentially they've got a lot more bargaining power to a certain extent, and also they're acting in their own capacity for a whole host of potentially different companies. So the position at law is that any IP that they generate is theirs. So it's really, really important with consultants to make sure that you have properly documented sets of terms and also deal with assignment issues of IP. Again, I know that's something that Jeff is going to come on and talk about a little bit later, but I think it's an important flag at this point. So I've talked quite a lot at length about those three interpretations of employment status. Really, those are from an employment perspective. So that is an employment law perspective, just to be clear. But there is quite a large overlap with the tax position, albeit that there are some differences with the tax position. And Sharon will come on and talk about this slightly later. But in essence, it's well worth getting advice both from an employment and tax perspective, because they may not always reach the same conclusion on whether or not someone is a genuine self-employed individual for employment purposes or for tax purposes. Then I suppose the only other category to talk about is non-executive directors. So again, you might be in a position where you're bringing someone onto your board to be the chairman. That might be to attend 4 regular board meetings a year. No other involvement in the business other than that. And in those circumstances, that individual, if they're appointed as a statutory director, would probably be a non-executive director. So they would be they wouldn't be subject to an employment contract. But again, you'd want some documented terms around their engagement, what services they're providing. And again, Sharon might comment on this later, but there is a relatively niche tax provision around them to say that they need to be paid through payroll for any services that they provide. So whereas consultants essentially invoice their time and are just billed for it, with NEDs, that's paid through PAYE. And that's something that we do see early stage companies not pick up on immediately. So that's quite an important issue to flag.
Well, you've mentioned Sharon repeatedly there, so I think it's probably time to ask Sharon's input. So there's your legal advice. Now here's tax term. So there are all sorts of gotchas in the tax world, aren't there, Sharon, in this particular thing? So the differences between interns, workers, employees, consultants, NEDs, etc., is quite a minefield. And there's a financial four character word in terms of IR35, which needs to be considered as well. So can we get the financial perspective on all of these different things, please, Sharon?
Thanks, Kathy, for that introduction, and thanks, Alex, for that clear explanation. Interestingly, you mentioned that word IR35. My answers today will be different to what they were a week ago, because there were some changes in the mini budget announced on that last Friday. So quite topical. But to stand back from it, so if we take those categories of that Alex talked about, sort of the employee, the worker, and the consultant, very, very broadly, the tax, in tax terms, it doesn't recognise three categories. You actually fall into one of two. You're either, for tax purposes, an employee, or you're self-employed. And so workers and some of the high level sort of press that's been on that, just because someone's deemed to have employment rights for legal purposes doesn't mean that they become employees for tax purposes. So I just wanted to make that point, not that we, as startups, are likely to sort of be in the position of Uber per se, but clearly, the principles do trickle down. So for employees, then, that's probably almost the easiest one to explain, in that I think most people are familiar with the tax implications of being an employee. You get paid your generally monthly salary. The company that employs you has an obligation to deduct income tax, as in PAYE, and the national insurance that you as an employee suffer from that, and pay that to you, and pay you the net amount, and then to pay over the employee's national insurance and the income tax, PAYE, to HMRC the following month. The employer also has to pay employers' national insurance, which is currently at 15.05%, but is going down to 13.8 on the 6th of November, and that was announced last week too. Fairly straightforward, I think, something to sort of understand. What then becomes more complicated is if someone isn't on an employment contract, but they are a consultant. So let's assume, for instance, that you have an individual who works in your business and they send you an invoice. Just because that is the mechanics of how you pay them doesn't necessarily take away from the company the need to assess whether they have the characteristics of an employee or not. Ultimately, it comes down to a balance of the actual on-the-ground arrangements that dictate that decision. So, if you take two extremes, for instance, let's say you have someone that comes in and helps you with your accounts, who probably gives you, I don't know, let's say 6 or 7 hours a week to your company. They also have other clients. It's up to them when they do that 6 to 7 hours. If that person isn't available, somebody else in their team could do that work instead. That sort of building, that sort of picture, they use their own computer to do that work, and that builds up to someone that really isn't part of your organisation. If instead you take someone who, for instance, is, let's say, an IT consultant, and they're coming in to help you to build some software, you want them to be in your office 3 days a week from 9 to 5:30. You say, you can only not work there for 4 weeks a year. You have to work between these hours. You have to report to someone. We'll give you a computer to help you work. It's only you we want. You can't substitute yourself. If you can see that picture, that is beginning, I'm sure you will appreciate, to feel more like an employee. So just because they happen to send you an invoice and you pay that invoice doesn't take your obligation away to do the payroll deductions and put them through PAYE that we were talking about with an employee. So there has to be a few bells ringing. So it's really important to think about each consultant that you take on and make sure that you are treating them right for tax purposes. And there are some tools on HMRC website that help you take you through some of those processes and help you see what side of the line you might fall. We then come on to something that we see quite commonly. So if we go back to that IT consultant scenario, for instance, instead of the IT consultant billing the company directly, they might have set up their own limited company, and that's called a personal service company. They will send you an invoice from their limited company instead. Where the tax rules have traditionally sat on that is that as the company paying those limited company invoices, you can take a fairly light approach to whether that person is an employee or a self-employed person. You can pay them, you can pay the invoices sent to you by the company, and then it's up to the company to determine, you know, whether it's a payroll relationship and whether and how to sort out their own taxes. And that relationship is called IR35, which is what Kathy alluded to a moment ago. That has been changing over the last few years, in that it has become the company that is paying the invoices responsibility in quite a lot of cases to actually still do that. Is it like an employee or not scenario? However, last Friday, effectively that change has been reversed. So we're now back to the position where very largely it is it's up to the personal service company, the person who is invoicing what would here be a spin out. It's their responsibility to sort out their taxes and to decide whether or not how that income is taxed. The point that Alex made about directors is probably the one that I really want to emphasize here. So you can get the situation where you have a non-executive director who has a personal service company, and they will send an invoice to the spin-out company via their limited company. And if you follow through what I've said, you know, it's all now been reversed, and that is up to the non-executive director to sort out their tax. The very fact that they are a director is not the case. So as any payments that you make to a director for them being a director, the revenue, the HMRC are really clear that it has to go through payroll. Now that can cause some implications for spin-outs. So for instance, you might have an academic at the university who becomes a director of the spin-out, but is also providing other services to the company. So for instance, you know, they may be the CTO, they might do some R&D for the company. In those sorts of situations, what we often sort of see is that that person actually has two contracts with the spin-out, one for their director services and one for their other more technical services. Every situation is different. And I think the takeaway here is, you know, just make sure that you get the right tax and legal advice if you are in that position, because it's really important to get it correct.
Yeah, I think I like the pain on your face there. That probably covers it all, don't we? So actually, I'm gonna follow on with that. I'm going to talk to both Alex and Jeff here about academic founders. So how do academic founders, particularly the ones who are staying in academia and just doing consultancy, how do they engage with spin-outs? Obviously, there's a possibility of two contracts needed, as Sharon alluded to there. How do we sort out, you know, today I'm a director and today I'm CTO and tomorrow I'm an academic? Some thoughts on that. I think I'm going to start with Alex, then go back to Sharon, and then leave Jeff to collect all the goodness at the end on IP.
Sure. So I mean, so from my perspective, yeah, absolutely what Sharon has said is what we see in practice. So what you might have is a situation where a founder it depends on what they are doing. So you might have a situation where an individual who has been connected with the establishment of the company is a director, but is only providing non-executive director services. So in those circumstances, you could have a separate NED consultant, an NED agreement, which again, depending on the legal and tax advice you get, there is no obligation to pay national minimum wage for that. So it may be that there is no fee payable, or it may be that there is a minimal fee payable for those directors' duties. And again, it would be important to ring fence what those directors' duties are. So is that attending board meetings? It's probably going to be limited to that if they are going to be involved, as Sharon said, in R&D, for example, because then what you would have is a separate consultancy agreement, either with them in their personal capacity or with them in a for a personal service company, so their own personal service company, where you essentially ring fence all of the other activities that they're doing. So nothing connected with their board duties, nothing connected with their director's duties, purely to provide services in relation to that R&D. In those circumstances, you could well have that separation of an NED agreement and then a separate consultancy agreement. Again, in both of them, IP is a consideration, and Jeff will be able to talk about that in a minute. But one of the other areas that we see is where, in reality, those directors' duties massively overlap with what they're doing on a day-to-day basis. So they're going out, they're talking to prospective clients, they're talking to prospective customers, they are essentially presenting themselves on a day-to-day basis of being the face of the company. They are dealing with essentially all external third parties. In those sorts of circumstances, it's very difficult to be able to argue that they are a genuine NED. And in fact, if someone is providing executive services, so a director providing executive services rather than non-executive services, then they should be subject to an employment contract and have all of the employment rights we've talked about. And then most importantly, be subject to national minimum wage. And again, Sharon might have some comments on this from her perspective, but this is one of the big issues that we see of founders coming into a company and having the view of, do you know what, like we've got 4 members of staff, I just want to make sure they're paid. I don't care about myself. Like at some point, I'll get some money out of this company. I don't want to pay myself. The difficulty there is there are actually minimum obligations under UK law that all employees, regardless of status of seniority, must be paid national minimum wage. And this is a consideration that doesn't just have sort of civil issues, it also potentially has criminal issues as well. So it's a really important issue to go and get advice on, because essentially if you fall foul of it, there could be criminal sanctions that fall on individuals as directors for conducting the business in that way. Sharon, I don't know if that might be a good point just for any comments that you might have on that, or what any of your experience on that.
I'd say it's something that's often missed, and yeah, you're right, absolutely needs to be factored in. HMRC have got a view that they like to whistle blow on people not paying the minimum wage. I suspect they're after the large companies to make examples of them, but equally, it's just as applicable to smaller companies. So you need to make sure you get it right.
That's one consideration. Another consideration is also at the time of spin out, what the obligations are with the university. So, for example, I've seen some spin outs where it says you must not be an employee of any third party, and therefore there's some considerations there about, okay, well, if that person is going to be engaged as a consultant, what are they actually going to do for the business, and who else potentially is going to be brought into the business to do the director's duties, to do the face of the company, if that person you originally thought was going to do that is potentially prohibited by those terms with the university. There's also quite a lot of crossover there in terms of restrictions on certain types of work, or when work is carried out, essentially who owns that work. And that's probably quite a neat point to hand over to Jeff to talk about IP.
Hi everyone. So yeah, when I look at these situations, it's normally in relation to intellectual property as kind of part of a fundraising deal or similar. But it's probably worth just taking a back step and actually just setting out kind of what the default rules on intellectual property are, and then we can kind of go from there and build up to how that kind of interplays with academic founders. But, as Alex has alluded to a number of times, it's a very important part of the process in terms of actually, figuring out where the intellectual property is and making sure that all of the necessary intellectual property that the company needs is either owned by the company or licensed to it, so that it actually has the rights to go about its business and kind of scale that and grow to the point of an exit. In the UK, there are some kind of default rules that apply under statute. So the first rule is that for an employee, if they are generating intellectual property in the course of their employment, the default position is that intellectual property is owned by the company. Now, usually, as Alex mentioned, we will have enhanced kind of intellectual property provisions just to really double down on that in any employment contract. But if for whatever reason they are not included in the employment contract, you can rely on that default position. It works very differently with consultants, where the default position under UK law is that the consultants own the intellectual property themselves, unless there is a position to the contrary in a written agreement. So essentially, consultants own the IP that they generate for the company, unless there is an agreement with the company that the company will own that intellectual property. But very rarely with kind of proper consultants, kind of advisors, etc., do we see that being an issue, because normally there's a good contract in place. I think the most common time, or the most common area where we see it being an issue, is sometimes where companies in the very early stages use a web developer or a web designer, a third party, to develop generate a website for them, or develop a logo as some sort of design agency, etc. And actually, quite often those design agencies will say, well, here's our contract, and they'll leave out any intellectual property provisions, because quite rightly in their minds, they want to kind of own that design, own the branding, own the look and feel of the website, and so that they can use it again. So quite often we have companies come to us and actually they've had a logo designed or they've had a website designed, but those service providers are essentially consultants, and without written provisions in a contract, they don't actually own the IP that they think they do. It also applies in a situation where you have general consultants that you're bringing in to work for the company. So you may have non-executive directors, you may have people that you bring in to do very specific tasks, help with a specific production element or design element, and it's really important for those consultants that they have robust intellectual property provisions in their consultancy agreements with the company to make sure that any intellectual property they generate is owned by the company. And if it's not automatically owned by the company, you normally have provision in there to say that the consultants will take any steps necessary to assign the intellectual property to the company, just so that it's completely clear that the company owns everything. And that's going to be really important when the company goes for a funding round, because an external investor will come in and will want to run due diligence on the company. And part of that due diligence will be to look at the company's intellectual property ownership and make sure the company has the right to use all of the intellectual property it thinks it does. And a consultancy agreement in writing that you can kind of put forward to them is a big part of that. So that's kind of, I guess, the background position, and it links in with academic founders because, as we've discussed, in a lot of cases, the academics are still employed by the university and will remain employed by the university, and they will have a consultancy relationship with the company. And there's almost a balance of interest here, because the academics will continue to generate intellectual property in their role as an employee of the university, and so the university will own that intellectual property. But they may also do additional work in their role as a consultant, where they are generating intellectual property that the company would want. And so there's some practical and there's some legal considerations with this. On a practical basis, I guess on a legal basis as well, it's really important that when you're putting in place a consultancy agreement with the academic founder, you are doing that in conjunction with, your contact at the university, the tech transfer office. It can't be the case that you just say, okay, you're a consultant, whatever you do in your consultancy role, kind of that's all owned by us, because actually there's a need to agree a position with the university to say, well, look, the university, this is what the university's happy with the academic founder doing for the company. This is when we're happy for the IP to be owned by the company. This is when he'll clearly be doing something in his university role. So actually that's going to be university IP. And of course, by this time, as part of the kind of spin out from the university, it would be expected that there would be an intellectual property license between the university and the company, where the university is saying, well, actually, all of the IP that we've generated in this subject, or a section of the IP we've generated in this subject, which essentially is intellectual property that those academics have generated through their research or through their university roles, that's licensed down to the company. Quite often there can be negotiations around improvements that the academics may make to that IP, and fairly often there'll be provisions about, well, what happens if they discover kind of related new IP as well. Either there's a provision for that, or there's an agreement that will look into other licenses in the future. So it needs to be something that's done kind of in conjunction with the university, speaking to the university about, okay, this is what the role that we envisage the consultant doing, this is what we want them to do for us. How does that overlay with the kind of the IP that they'll be generating for the university and the university's claims on the academic's IP, and kind of trying to form a position that everyone's happy with. And then there are some practical considerations and practical things that you can do to help that situation. Alex has touched on some of them, but it's things like, having separate notebooks for, academics having separate notebooks or separate laptops for the work they do for the university versus the work that they do for the company. It can be quite dramatic things, such as, having separate labs, if that's a possibility, so that we know that, if the academic is working for the company under their consultancy agreement, then they're going to be in the company's lab working there, and that's kind of a clear definition. But if that's not possible, if lab space is unavailable, if the company doesn't own lab space, if it can't afford to rent it, then things like having separate laptops, having separate notebooks, having as much as you can kind of clear working hours or days when you're working for the university, when you're working for the company, just trying to keep some sort of separation as best as possible between the works that you're doing, so that there's a record that you can say, well, this is the work that I've done for the university, and this is the intellectual property that falls under my employment for the university, and this is the work that I've done when I've been contracted as a consultant. And just showing that actually the work that you're doing under a consultancy basis doesn't touch the sorts of work that you're doing for the university. So it gets kind of muddied sometimes when you have academics that are doing a research project for the university, and then they're also researching a similar area for the consultancy, and again, you just kind of need to work with the university on that. But it works quite well where you're spinning out research that you've already done, and actually you're under your academic life, you're kind of going on to research other areas or different things to what you're researching or continuing to commercialize for the consultancy, for the company that you're a consultant to. So
it's one of the reasons why the university is so adamant we should have conflict of interest plans, so that we can actually recognize when we're in the wrong notebook or in the wrong laptop or whatever. So they're not there just to be annoying, frustrating pieces of paper. They're actually genuinely there to address exactly what you've all just described. We've looked at starting out, how we categorize the types of people working for us, how we deal with this really complicated situation with academic founders, and we try and keep that sweet. The next perturbation we throw into the mix is, and what if somebody is based overseas? Because we've talked about the law here, and employment law here, and IP law here. But what if you've got some overseas stuff? So I think I'm going to start with the tax side of this. Sharon, what are the implications of somebody being overseas and part of your team from a tax and financial perspective?
Yeah, there's always two sides of things to look at here. But I think the overriding thing you need to take away is get a buy sooner than later, because it's very easy to trip up from a tax perspective where you venture outside the UK. You can't get a buy soon enough, and if you take one thing away from this bit of the talk, it should be that. But very, very broadly, we talked a little while ago about where you had employees, and that you had the company had obligation to operate payroll and to take taxes and pay those over to HMRC. Very, very broadly, most countries in the world will have something similar. So if you are going to take on an employee somewhere else, you should not pay them until you have sorted out whether you as a company have an obligation to deduct payroll taxes or to pay social security in relation to what you pay them. So I can't really give you more specific advice than that, because obviously it very much depends on which country you go to. But you know, do remember that. And the other thing to remember is it always takes longer to set these things up that you might imagine. Sometimes for instance, you will even need to have a bank account in the overseas country. And you know, those of you who tried to set up bank accounts in the UK recently will know that takes time, and sometimes overseas it can take even longer. So that's from sort of the payroll side of things. You also have to think a little bit further than that, though, in that if you are a company and you have got operations overseas, do you have some sort of obligation to register the company overseas for, you know, its own taxes? So, you know, what we call over here corporation tax or something like that. Now, you might think, oh, I'm a spin out, I'm not generating any income yet, this isn't important, etc., etc. But it can be. There can be penalties if you don't register, even if you aren't, you know, effectively tax paying at that moment in time. So the other thing you need to consider is corporation tax, or as it's called in the US, for instance, corporate income tax, or something along those lines. If you are in that situation, then you have to then decide, shall I set up a different company in that overseas territory or not? And that's a very big topic, and not one that we need to go into today. You could just operate as a branch overseas, so you actually do the tax registration but still just have your UK company. Or it might be better if you actually set up a separate company as a subsidiary of your UK company that carries out those activities overseas. That decision is not just a tax decision, it can be a legal decision as well. It can depend on what you're doing overseas, what the regulatory environment is like over there, whether you want limited liability overseas, lots and lots and lots to think on. And I don't want to step on Alex and Jeff's toes here, but no, if the second you go outside the UK, please take tax advice. It's really, really important.
You will see in the chat that Nicola has put up a sort of summary document, the Guide to Global Employment Law, which you can all access and download. Right, so shall we go to Jeff first, because you always get left to the end, and I think we ought to give you a chance to overspeak Alex on this occasion.
Perfect. I wouldn't dream of that. Yes, I guess from an employment law point of view, Alex can talk more to it, but the I guess the overriding position is that there is no single set of employment law rules, just like there are no single set of tax rules. And so every jurisdiction may have slightly different rules and regulations that you need to abide by, which, you know, it's not just a case of actually going to get tax advice in that jurisdiction. You're going to need to go and get local council advice as well there, potentially. There are employee of record systems that Alex can speak more about for hiring overseas, where you don't have subsidiaries there. I tend to get involved and look at things more from a share option and kind of employee incentive side, and we'll come on to this more in some of the other sessions. But it comes back to Sharon's point that a lot of what we do with share options and employee incentives is steeped in tax. It's, you know, what's the most tax efficient way to get employees equity and give them an incentive and a sense of ownership when the company has some value. Because there are no there's not one single one-size-fits-all kind of tax regime across the world. Every jurisdiction has its own different tax rules, and so every jurisdiction will have its own potentially different schemes as to how you can, you know, incentivize employees from an equity point of view. So, you know, some of you may have heard of EMI options, which is what tends to be that kind of the gold standard for startups and scale-ups in the UK, and most of our clients will have an EMI scheme, but they can't roll that out to employees in other jurisdictions. It won't, you know, they will be subject to the tax rules in that jurisdiction, so the EMI tax advantages won't apply to them. And so when you have employees in other jurisdictions, or when you have employees that start out in the UK and then move to other jurisdictions. We had that a lot in the pandemic when people actually realised, when everyone started to switch to remote working, we had a number of employees, companies with employees that realised they didn't have to be in the UK anymore. They could, go wherever they wanted to go in the world and still work remotely from home. But when you have those positions, it's important to consider, actually, can we put in place a tax efficient scheme in that jurisdiction? Is there the ability to do so? What does that look like? If you wanted to do that in a tax efficient manner, because it's very easy to give people options and then those options just be subject to whatever the tax rules are in that jurisdiction. If you wanted to put in something more tax efficient, you would need local counsel and local tax advice to discuss the best ways to do that in order to ensure you meet the requirements in that country. But you also have to think of it from a cost benefit analysis point of view. And, we have this discussion with clients all the time when they say, okay, we've got our option scheme in the UK for UK staff. We're hiring, kind of a couple of employees in Germany. What can we do in Germany, for example? And there are schemes that they can put in place, but it's going to cost them kind of, 5,000 euros plus to put that in and actually adopt a scheme. And so you have to kind of do it on a cost benefit of how much is it going to cost me to implement this versus how many employees do I actually have in that country, and is it worthwhile doing that at this stage, or should I hold off until I've got more of an employee base in that country. So that's kind of my 2 cents. Alex, I probably left quite a lot for you to cover in terms of employees of record and stuff like that. But
I think Jeff's key point there was that there is no unilateral system, and in a increasingly globalized world where anyone anywhere in the world could have jumped onto this meeting, it wouldn't matter, be able to contribute in exactly the same way. It does still surprise a lot of early stage businesses that there is not a unilateral position, but ultimately there's not. So each jurisdiction has its own particular employment laws, it has its own corporate laws, intellectual property laws, tax legislation. So each jurisdiction is different. And again, going back to what Jeff has talked about in terms of cost benefit analysis, that's one of the conversations that I have with clients at a particular stage. So if a client was telling me, look, actually there's 10 employees that we really need in Germany, and actually we're building a presence in Germany because we want to enter the German market, there's particular reasons for doing so, then there's clear rationale and justification there to incur what would be potentially quite substantial costs in those jurisdictions, understanding the legal landscape, the tax landscape, setting up payroll in that jurisdiction and essentially paying a company in that jurisdiction to manage that for you, potentially dealing with all of those legal and tax considerations. But and just to add to that, in terms of our capabilities there, Nicola's obviously shared those global employment law guides. We're in a position to work with local councils. So we have essentially a local council network across the world where in most jurisdictions we have a contact that we are familiar with, who we are able to approach to act on clients' behalf. And then essentially we know that advice is going to be similarly commercial, similarly pragmatic to the advice that we would provide. And we can then present that essentially as one product to clients. But in terms of those considerations, that type of working model works where, as I said, you've got a large number of employees, you've got a particular reason for a jurisdiction. But quite a lot of the overseas issues for early stage companies come up with a situation where Bob has worked in the UK for the last 15 years. He has been UK based, but for one reason or another in his personal life, he now wants to move to the south of France. Now he is the only person in the south of France. He's the only person in France. So your considerations there are, well, do we really want to go through all of the cost implications for that one employee? Let's just say they're a business critical employee, so we're not going to prohibit them from going. But so we want to support them in going, but are we really going to go through all of those tax and legal implications, potentially have to deal with a whole heap of French law to and set up potential issues there? Or alternatively, would we look at some sort of commercial model which manages a large number of those risks for us, so or practices for us. So this is where employers of records come in, which Jeff had sort of alluded to. And essentially these are third-party commercial organisations that have presences in a number of jurisdictions. Essentially, you approach them, you agree a commercial contract with them to employ the individual on your behalf in that jurisdiction, wherever that may be. So let's just say you've gone out and you're looking for someone in Estonia who's a software engineer. Okay, again, you're not going to potentially look at the cost of setting up an Estonian entity, what the implications are in Estonia. You reach out to an employer of record, they employ that person in Estonia for you, but they have a commercial contract with you with a whole set of commercial terms, and essentially you pay over and above what it might cost you on a typical day basis to employ that individual directly, but it saves you a lot of the upfront costs of setting up an entity, for example, if that's what's necessary, complying with local tax laws, setting up payroll. So these companies manage that for you, but you pay a premium to them to manage that for you. But quite a lot of early stage companies, particularly those where it is one employee in a particular jurisdiction, consider that actually those employer of record type models are best for them commercially. Again, ultimately it's a commercial decision, but that's just a bit of an indication of some of the work that I've been involved in.
Excellent. So it's a very complex process is recruitment, but for companies right at the beginning, what are the key considerations at the point of recruitment? What sort of things would you consider? And I'm going to go back to Alex, perhaps sort of look at some competitiveness in the market, flexibility, incentives, that sort of thing. And then I'll pick on Jeff and Sharon. Sure.
So, I mean, I think we're all aware that at the moment there is quite a unique situation of, despite the economic climate, essentially a real desire for talent, particularly in the UK. And that's made the employment marketplace very, very competitive at the moment. And typically, let's say 5-10 years ago, the things that you'd probably be looking at really would be salary or benefits, essentially as simple as that. So potentially paying more than a competitor, potentially providing permanent healthcare, for example, maybe a company car, those types of considerations. To a degree, they're still there, but to a certain extent, they have gone out the window. Flexibility post-COVID is absolutely huge. So the sort of main methods now of incentivization that we see are flexibility in terms of where to work, how to work, time commitments, family-friendly policies, whether or not they are enhanced, what they potentially mean for an individual. Again, the ability to potentially make flexible working requests. And then alongside that, then you have issues of, as we talked about, salary, which is always going to be a driver, but also location. And ultimately, what I always say to early stage companies as well is that, to a certain extent, some of the talent that you are bringing in, you're not going to be able to compete with the conglomerates who potentially offer a whole host of benefits. So you actually just sort of need to take a step back and ask yourself, what are you offering? Which is probably a relatively unique proposition for someone to have a lot more responsibility than they ever would do in a conglomerate, for them to essentially have the ability to shape the business going forward, and also to shape those potential policies and changes to the businesses going forward. So that in itself is a real positive that I think some early stage companies do overlook, and I think it's a really important message to emphasize that early stage companies are unique for a particular reason, but that is a massive advantage. It's not always that you're massively far behind because you can't offer what a conglomerate can because of cost issues. So that's sort of the main things from my perspective. I mean, I know that Jeff is probably going to talk about EMI, so I'll let him do that. And fruit bowls as well. He loves talking about fruit bowls.
I was going to say, you didn't mention the fruit bowls this time, and that's disappointed me greatly. It isn't, yeah, so I'll touch on the fruit bowls point, but it's just a case of, like, and as Alex said, you know, as a startup, as a scale up, you have a chance to do things slightly differently, and you have a chance to kind of create the culture that you want to create. So, you know, myself and Alex and Nicola spend a lot of time visiting clients, and the more, like, the clients that I look forward to, like, kind of going to see the most are kind of the startup scale up clients, because they're in cool workspaces. They're, you know, it's an atmosphere and a culture that's different, and you can really kind of shape and drive that, but also promote that when you're actually recruiting. As Alex said, it's important. You know, you're not going to be able to compete on salary, and there are ways that we can try and kind of rebalance that a little bit, and options are one of them. But actually, the other ways are things like creating a culture. So fruit bowls comes from the fact that one of the things that I really like about working at Taylor Vinters is that in all of our offices, there's a fresh fruit bowl every day, or in the Oxford office with Nicola, there's kind of a velvetizer station. It's that kind of stuff, which is just like, it sounds kind of silly, but those little perks that, you know, a big corporate may not have or may overlook, and it may just be a load of desks. You know, you can set up your working spaces in different ways. You can work in cool and interesting spaces, and you can kind of design it how you want to design it. You know, I've gone to see companies before that they did a big kind of Series A round and then brought out their own branded beer for the office with their logo on. And that may be going slightly too far, because I don't know quite how they squared that with investors, you know, saying, okay, well, we're going to take loads of your money and spend it on branded beer. But, you know, it's those sorts of things that actually give people a sense of kind of enjoyment, a sense of togetherness, you know, that just being in the office, that actually should be promoted. And, you know, you have the chance to shape and drive that yourselves. In order, you know, when Alex talks about salary, you know, you're not going to be able to compete with big pharma companies, with big tech, with your Samsungs, your Googles, etc. But we can offer other things, and one of those things is share options. So essentially, share options are an option for the employee to have shares at some point in the future, but it gives them a right to ownership at some point in the future. And so share options are a really nice way to reward people for work they've done. Quite often, by the time you put them in place, you probably have a founding group of core employees that have taken the plunge to join a startup and have already done a lot of good work for you. But they're a really good way to incentivize people to stay with the company and to drive the company forward. You know, the option denotes the right to a share. The share, you know, the share will increase in value as the company increases in value. So it really means that, you know, if employees have shares, they have a sense of ownership, they feel like they are part of the company, but also there's a big financial reward that will get greater as the company grows and achieves more successes. So it kind of incentivizes everyone to work as hard as they can to grow the company for that purpose. We will touch more on options next week, so I don't want to say too much about them. I've mentioned kind of EMI, which is the most tax advantageous form of option that we have in the UK. It's what we'll talk about probably most. You know, probably we'll talk about it most in the next session. That will be kind of heavily EMI skewed. But yeah, that's kind of options will be a good balance, something else you can offer companies. I'm seeing lots of chat about velvetizers. A velvetizer is essentially a very expensive milk frother. It's not even that very expensive. It's essentially Hotel Chocolat have brought out their own kind of all-in-one milk frothing station that you kind of put the milk and the hot chocolate into one machine, and within 2 minutes you've got perfect Hotel Chocolat style milk, like hot chocolate. Nicola's a big fan. I'm a big fan. I would implore everyone to buy one for their offices.
A well-spent £100 for your employees, obviously.
Yeah, exactly.
So I used to work at a company where we had ice cream Tuesdays during the summer, and the boss used to come in with a load of ice creams put in the freezers, and yeah, that was the startup perk of the century at that point. Anyway, back to more sensible things. Payroll. You know, the advantages of options and ice creams and velvetizers are all patently clear, but I think most people would like to be sure that they get paid regularly, on time and appropriately. Sharon, how do we set up good working practices?
Talking a moment ago about payroll and making sure if you went overseas that you got registered early, exactly the same thing happens in the UK. And again, to be able to operate payroll in the UK, you need a bank account, and that might seem obvious, But I can't stress how important it is for a new startup to get the ball rolling, both on getting the bank account set up and on getting the registrations done with HMRC to make sure that you can pay people appropriately and to make the right deductions and pay those over to the authorities. That, like anything else these days, has become much more. HMRC are trying to make things more automatic to be able to do a lot of these things online, and that's great, and I applaud that massively. However, that does have some implications in that it means that it's much harder, for instance, for you to apply an agent to do that registration for you. You might have to be at your registered office to get passwords sent to you, which may or may not be an issue if you haven't, secured your office space yet. These are just all examples of things that can easily go wrong. So, just make sure that it's done sooner rather than later. As far as operating the payroll is concerned, it is tempting to do it yourself. I would say it's the thing that is probably most complicated as far as accounting and tax is concerned. That for a startup, it's very easy to get it wrong, and more often than not, it might be sensible to outsource that to a payroll company or to the accountants that you use who might run that service. And so it goes without saying, that's something that we do for a lot of startups and a lot of companies, but worth considering. It's probably just easier than trying to get someone to do it in-house. Alex mentioned benefits. It's really important that if you are providing benefits, that you think about the tax implications of that both ways, really. One, in that if you are giving someone a benefit, they understand if that is going to result in a tax charge on them, so there's no nasty surprises. But equally, that you could take advantage of some of the good tax benefits that are available. So, for instance, the Cycle to Work scheme, very, very popular, where you can help your employees purchase a bike, and there are tax breaks. Electric cars, electric charge points, all those sorts of things are all worth thinking about, because they can add up to something that's a good package for employees. Just to touch a little bit as well on what Jeff and Alex were saying about attracting people, we are finding that when we take people on now, as well as benefits and payroll, and whether you have a fruit bowl and those sorts of things, people are really interested in three things. One, it's your equality and diversity policy. Two is your approach to environmental issues, and thirdly, what you do as far as the charity and the community is concerned. The latter one may be difficult to do financially, but for instance, you could give people some time off to go and do some community work or something, which wouldn't necessarily cost the spin out something, but is, it sends a good message. So I know that's not tax, but I just add that because I think that's important to think about when you're thinking about how you can build the team that you want.
That's actually a good thought. Yeah, making sure that the things that people value are built in. And I think we'll have to do a whole session on equality and diversity at some point, Nicola, but actually there is an equality and diversity premium as in business. The more diverse and more equitable your organization, the better your business will run. And that's factually substantiated by quite significant research. So, it's worth making sure you're doing that. And if you're not sure how to approach that, again, kind of give us a call and we will help direct you to some great wisdom in that. Anyway, that strays off what we were looking at today. I think we've pretty well come to the end of the stuff we were going to try and cover today, unless any of my assembled esteemed co-partners in crime charge me to the ground and say no. Then I would propose that we move to any questions that people might have. Said in here, so there are invitations to go and visit the Velvetizer. I'm about to put in a request to have one in our OUI central office in Little Clarendon Street. I'm sure I'll get beaten for that. James, you've asked Sharon could you comment on the use of services like Just Payroll Services.co.uk instead of doing this in-house? And is there a point where you'd switch from one to the other? And somebody has said, always outsource your payroll.
I would agree with that. I think, I mean, we do have a payroll offering at James Cooper Preston called JC Payroll. We have some massive companies that choose to put their payroll with us, as well as some, a large number of small startups, spin out type companies. It is the thing that you can get wrong. I would echo that. Always best to outsource your payroll. The time it takes for someone that doesn't do it very often, that time can possibly be by far better used in running the company. I have seen things where I've had even the CEO trying to run the payroll. If you think what they could do at the time that takes, to me that just seems sensible.
Okay, and just a request, Nicola, could you comment on the One Model link that you put up there?
Sure. So this was just so Alex mentioned this briefly, but the One Model is a program or a concept, an offering of where you can coordinate, or we can coordinate your international legal advice on your behalf. And so you only have to deal with one lawyer, one time zone, one language, one invoice. And it also means by sort of going out to our respective counterparts in the different jurisdictions, that we can actually find lawyers that are like us. So lawyers that you are used to dealing with. Another benefit of it is that we're not actually part of an international group, because sometimes when you find with law firms that are part of an international group, you have to give work to that particular company or that particular law firm in a different jurisdiction, and you're not always top of their list. And actually the sorts of law that they might do and the approaches they might have might be very different to the sorts of approaches that we have. So we don't have a formal network. We have an alliance of friends which gives us a choice of firms in each jurisdiction that is actually tailored to the needs and the advice that you actually need. So basically it's like being an in-house counsel, but for international work.
So there's been a question about costs. I'm going to answer this one on behalf of everybody. So it is my experience over 15 years in this space that you get what you pay for. I think it would be not unreasonable to say that the lovely people on this call, they're definitely not the bargain basement department, but I've never felt that we were overcharged for anything that we did, and I know they work very hard to deliver incredibly good services. So as a bunch of friends that I will turn to, I would strongly recommend, and you can always go to people, professional advisors like Taylor Vinters, James Cooper Preston, or others, and ask for an indication of what sort of price for the sort of thing that you're after. Bearing in mind that sometimes there are non-straight lines and things may go wrong, but usually a good professional advisor will keep you appraised of anything that would be not expected within that process. So if you want something simple, straightforward and within the lines, then you'll get you'll be able to get an indication of price. And I think it's probably best done on a case by case rather than a generic basis. So if you have specific needs, talk to these people, ask them the sort of price that it would be, and get an indication. Is that fair, folks?
Very. As always, very diplomatic. I mean, I think it is fair to say, obviously, we are very much used to working with early stage companies right the way through their funding journey. And so, we do very much take a view with regard to sort of costs relating to things, and try and keep it as simple as possible, and not make it complicated right from the outset. And we're definitely not lawyers who sit there with a clock ticking in the background. I hate the idea that somebody wouldn't ask a question because they thought that there was a clock ticking somewhere. I'd rather be you know, sort of the person that is there at the end of the phone. Quite often for lots of non-legal stuff it would appear as well. But yeah, and you know, velvetizers, recipes, that kind of thing.
Yeah, I think that sounds fair. And yes, it is very much the case that if you get it wrong, the cost of repair. So I'm going to give a specific example. I was involved with an early stage company back in my previous employment before I came to Oxford. And the company chose to set up an option scheme, but it neither read the instructions nor got advice, with the consequence that the option scheme was not compliant. It had absolutely no tax benefits whatsoever. It was simply a bucket of shares that hadn't been allocated that were then handed to employees along with a very large tax bill. It was a total disaster, and in the end the company failed. It was never going to succeed because it just simply couldn't do the basics right. And the employees obviously were furious with what happened, and yes, you can imagine how that went. The cost of repairing it, well, it was actually irreparable, but the cost of making it as good as it could be was far higher than, by a factor, I think, of about 10 than the cost of taking the advice in the first place. And I had the unsatisfactory opportunity to say, I told you so.
I always say I like my litigation colleagues, but I don't like them enough to want to give them a load of work.
Priceless. Okay, let's draw today to a close. Thank you very much to everyone. Please do make sure you've got the dates for the next 2 online and the in-person information as well. Then we look forward to seeing you there. Any problems, get in touch with any one of us and we will assist you in getting squared away with anything you need. Okay, sure. Including hot chocolate.
Including hot chocolate, which you can also use for cocktails in the summer, but that's a whole other session.
I think we ought to have a whole session on beverages.
I'll tell you what, why don't I bring the velvetizer to the in-person workshop?
I think we might have to have more than one, mightn't we?